Good morning, everyone. My name is Sam S. Stryker. I teach labor and employment law here at NYU Law School for more years than I care to tell you, and have been the director of the Center for Labor and Employment Law since about 1994-93. This is the 71st NYU Annual Conference on Labor. The Annual Conference on Labor is older than I am, but I also have not been there since the beginning. The conference was started in 1947 during the year of the Taft-Hartley amendments to the National Labor Relations Act, and we believe it is the premier forum for bringing together practitioners and academics from both the labor and employee, labor and management, labor/employee and management sides of the controversy. We try to devote a conference to a theme, and the theme this year is initiatives, proposals, and developments during the first 2 years of the Trump administration. And we're going to start with Janus. Now, we don't know how Janus is going to come out, and I should tell you that I am loath to make predictions about short-term predictions. I am very loath to make. I am willing to tell you how the economy will fare in 30 years. I'm willing to tell you what the union density rate is going to be in 30 years. Any questions you have 30 years from now, I am willing to share with you. But anything about what's going to happen in 2 weeks or 2 years, I'm not going to tell you, because I fear that my prediction will be invalidated by subsequent events, and I will be here to hear about it. So 30 years out, you have me, 100% infallibility. Fred Braid, who's a member of the Center for Labor and Employment Law, is our moderator for this session. The Center for Labor and Employment Law has an advisory board of distinguished practitioners, as I said, from the employee/union and management sides. They donate their time and resources to the functioning of the center, and so we are very much indebted to them. The conference is one of our centerpiece programs, and we would not be able to actually function without our advisory board members. So I'll turn it over to Fred Braid for a moment.
Okay. Thank you, Sam. What Sam didn't tell you is that he's actually been in charge of the Center for Labor and Employment Law here at NYU for the last 23 of the 71 years that it has been in existence. I like to refer to the group, the advisory body, as Sam's Club. As you know or may know, Janus is still pending decision, and we have, in addition to Sam, who will teach us everything about the law, Alan Klinger from the Strzok law firm, where Alan is active in representing public sector unions, which of course will be directly affected by the decision in Janus, and also does work with employee benefit funds, among many other hats that he wears at Strzok and Levin. And so without any further ado, I don't know who's going to start this off,
Let me just say just a few words for a second. Alan is not only the distinguished outside counsel for the United Federation of Teachers and the Sanitation Men's Association, but he's also the managing partner of Strzok and Levin. And in fact, this is an achievement I'd like to see more of our labor and employment lawyers achieve, not only being proficient in their field, but running major law firms, because then they in turn give us a small piece of their success as alumni of the law school or alumni of the center. Alan's a terrific fellow, and I'm glad he's a member of our advisory board. We were going to structure this as an informal conversation, maybe have Alan start with some ideas that he has. Obviously, the public sector union movement is very much concerned about the Janus case. As I say, I don't make short-term predictions, but we know that the very same issue was before the Supreme Court 2 years ago in the Friedrich case. Then divine intervention occurred, and Justice Scalia unfortunately died. So they couldn't decide the issue 2 years ago. That case was called Friedrich. But they've taken the case again. It's shorn of one of the issues. There had been an issue about whether it had to be opt-in or opt-out. That's not formally at issue. The issue is will the Supreme Court's decision in Abood, which was written by my former boss, Lewis Powell, I think was a 1987 decision, is that decision going to be overturned because of it's no longer is worthy of stare decisis? Anyway, that's the basic issue before the Supreme Court. Alan, why don't you take it?
Certainly, and it's actually even longer than that. It's 77, so it has
77.
So it has decades of people relying on it. And what the case, and what one, unlike Sam, I'm willing to make a prediction. Either this coming Monday or the following Monday, the public sector union side is going to lose. What we don't know is how broad the loss is going to be. What this case is about in a nutshell is, what Abood did was adopted the principle from the private sector that said that you don't have to be a member of the union, but if you're not a member of the union, you have to pay your fair share of what a union does for you in terms of collective bargaining, contract administration, grievance proceedings. What you don't have to do is to support that part of the union's activity that was viewed as political, because that would be a forced association. And what the Abood Court did was to do what was thought at the time was to be a careful balancing analysis that would serve the rights of all that were involved. And this has worked. It varied state by state or within municipalities as to what was viewed as chargeable, that is, what was being done for everyone, versus what was not chargeable, which the worker didn't have to pay. And there were from time to time issues about that, and there were procedures for having that resolved. Fast forward a number of years, Justice Alito starts inviting an attack on this in a series of decisions, which, as Sam says, at first was in Friedrichs and now culminated in the case that's before. The argument being that, in essence, just to step back for a second, is that one of the things Strzok submitted an amicus brief on behalf of the New York City Municipal Labor Committee, which is the consortium of all the public unions. And we participated in the preparation of the argument. It was argued by very able attorneys from AFSCME. And one of the things that's interesting for those people who practice in the Supreme Court is that you don't just look at the law, you look at the predilections of the individual justices and who it is you're trying to sway. Believe it or not, in Friedrichs, the view was that the target should be Justice Scalia, because Justice Scalia had embraced in other decisions the notion of the free rider construct, which is both an economic and political/sociological view, which reduces to, if you can get the same benefits, the same attributes, and not have to pay for it, many rational people will choose to not pay for it. And that was something that Justice Scalia had recognized. The way that the bargaining system works, and we'll get back to this a little bit later, is that the union is the exclusive, if the union is duly elected, it is the exclusive bargaining representative for everyone, whether you supported the union or not. And this has certain advantages of efficiency, predictability, that the employer has someone that it can bargain with and know that a result will be obtained, and workers know what to expect as well. So what happens here is that you have to represent everyone. That was the system for this. So now what you have is a system where the worker, even if the worker doesn't pay, isn't a member of the union, the workers' rights are still being protected. And this was something this notion seemed to bother Justice Scalia in other cases. We were down at the argument. It's very exciting to be at the Supreme Court. Unlike Sam, I didn't get to clerk for the United States Supreme Court. It is very impressive to be there. We're there in the setting, we're prepared. The very first question Justice Scalia asks is, isn't anything and everything a public sector union does inherently political because you're dealing with taxpayer money? So whereas you can't always know how a judge is going to vote depending on the questions, our hearts sank. Fast forward now to Janus. This time, the issue was we were aiming at Justice Kennedy because of some of the questions that were asked during the prior oral argument. What was trying to establish is that there is a well-recognized difference between the government as employer versus the government as sovereign. Those of you who have followed the law in the First Amendment context, Garcetti and others, have said that it's okay for the government to sort of, recognize this, and not everything flows. And that was our argument, and it was aimed at Justice Kennedy. And Justice Kennedy, who I don't personally know, but comes off in the press as a balanced, very decent person, he excoriated the Union Council about everything a union is interested in is just getting more money at the expense of the taxpayers, and that for teachers' unions, all you want is to protect tenure. So again, we are not optimistic and willing to make this prediction of what that would be. So one of the things that Sam asked that we consider today is, can public sector's unions exist in a post-Janus world? We believe collectively that the answer is yes. Sam and I have spoken about this, and we wanted to sort of put out why. And the reason that I think that it's relevant, because at first I was thinking, for this type of audience, why did Sam lead with a public sector union case that doesn't impact everyone in the room? And I think it's in part because, look, it doesn't follow exclusively, but with what has happened with the union movement nationwide, the public sector unions have retained a lot of their force over the last 10, 20 years. Private sector has been more challenged. The right wing, and I'm not trying to use pejorative terminology, but commonly viewed as the right wing, has targeted the public sector unions because they are a major funding and organizing source for the Democratic Party. And do think that's why this decision has ramifications beyond just what happens in the public sector workplace.
If I could just interject there for a moment. People think that a negative decision from the union standpoint in Janus is going to be limited to the government sector. That's not entirely clear. If you know the history of the way this doctrine evolved, it evolved initially from the Railway Labor Act, where it was felt that there was enough state action in the Railway Labor Act to apply these principles. This is pre-Abood. And those principles were then used in public sector cases. And then the Supreme Court, in an opinion by Justice Brennan, we can talk about this later, a case called Beck versus Communication Workers, essentially read the Railway Labor Act precedents into the National Labor Relations Act, even though there is not a state action. So it's at least an open issue whether a negative decision from the union standpoint in Janus will filter into the private sector as well.
Yeah.
We can talk about it later on.
And the Taylor Law, which is the state labor law, recently celebrated its 50th anniversary. There was a program in Albany, co-sponsored by PERB and the Columbia ILR School, and Professor Estlin of this law
Not the
school.
Columbia ILR School.
I'm sorry,
I take
Cornell.
a little
No,
umbrage.
no,
Because
Cornell.
one, I'm a graduate of the
Right.
Cornell ILR
Sorry.
School, and two, Columbia, even though I'm a graduate of Columbia, we are currently in a competitive, rivalrous position with them. It is the Cornell ILR
Yes,
School.
sorry. Of which my middle child is a graduate, so that really is an embarrassing slip. But Professor Estlin of this law school gave one of the keynote addresses, and she actually predicted that the attack is, as Sam says, going to extend into the private sector on issues of fair share or agency fee, it's sometimes called, and even possibly the principle of exclusivity, which we'll get to later.
You're going to talk, can we talk about exclusivity for a
Sure.
moment? Why is it functionally necessary in the public sector context?
The reason is, and again, one of the ways, because what we were transitioning to, and this is a good point Sam raised, what we're transitioning is what should public sector unions do? Because just 1 second before we get to Sam, another thing we can safely predict, many public sector unions are going to lose members because of the free rider syndrome, or because some of them just don't believe in their union, and that is something that unions need to face. And that it was one thing when you had to pay your fair share, which was often 90 cents on the dollar, and a lot of people felt, well, if I had to pay 90 cents on the dollar, I might as well pay the full dollar and not have issues with my colleagues as to why I'm not with the union. That's going to change. What we have seen as laboratories for this is that there are a number of states in the last 10 years have gone right to work within those states, and public sector unions lose members. some not as many as others. The hope is that in New York, being more of a blue state, and with the unions being stronger, that there'll be less of it, but they're going to lose members. One of the proposals out there is, so that unions don't suffer from the free rider syndrome, is that they represent only members. What was that? Is that if one of the antidotes to this that's being proposed, so that unions don't have to basically subsidize or pay for people that aren't members, is to allow the unions to say, we're only going to represent members. If you're not a member, we no longer have to represent you. That impacts, and that actually I can tell you was the reaction of a number of public sector labor leaders in New York. The problem with that, which is what Sam is getting at, is that if you lose your right to be the exclusive bargaining representative, what does that mean? It means, one, the employer can offer people who aren't members of the union a better package, and that will undermine the union. What could also happen is that you can have multiple organizations trying to represent the workforce, and so then you can then have divisive activities within your own side, and people say, and then some of those might be, quote, friendlier, close quote, to management. One of the issues out there is another possible remedy is having employers give better pay for things for the union to defray their loss of money, and that we'll get into briefly, but that's another issue.
But just on exclusivity for...
But on exclusivity is that management also doesn't want to lose having an exclusive representative, because what's very interesting is that, first thinking is that, why did the city of New York submit an amicus brief in both Friedrichs and Janus in support of the union side? The city of New York submitted a brief because they said, we want to have one representative to bargain against, to bargain with / bargain against, because this adds, it's more efficient, it adds predictability, and they actually want the union to have decent resources so that the workers have confidence in the union, so that there's a operating procedure. Because what has happened is that not too many people in this room are old enough to remember, but in the 1960s and 70s, New York City was hit with a number of public sector worker strikes. What was done in New York City with the collective bargaining law, the overlay of the Taylor law, was to bring a system that people trusted, that allowed for ways to bring about a collective resolution or an impasse arbitration procedure to reconcile, so that there would be labor peace. And that's really the compelling interest that's there.
If I can add another point, just imagine a union that adopts a members-only position. I don't think they're solving their problem. They're going to negotiate a salary increase. It can't be limited to union members. So there's going to be an inevitable free rider problem. It can't be limited to union members, because where there's an employee desire to be represented by a labor union, these employees tend to be similarly situated, and what they care about is horizontal equity. I always tell this joke, if one of my colleagues is in the room, Professor Eslin or her husband, Professor Zakharov, I don't care what I get paid, as long as I get the same that they're getting. And so that impulse, which is a very important part of collective bargaining environments, suggests that you can't really confine the wage increase improvements you come up with to union members. So too, I think, with grievance adjustment. You're going to have a contract, and it's only going to be enforceable with respect to union members. It's just not what we call an equilibrium situation. So I don't think it's going to solve the problem, unless the union wants to sort of argue itself out of existence. In Europe, where we do have members-only unionism, we have multiple labor organizations, and they do not bargain at the level of the firm. They bargain multi-enterprise, minimum wages across an enormous geographic section. They don't have, what we have is bargaining at the level of the employer. So I think that the members-only solution is not a solution. Do you agree with me there?
Yes, very much. And I can tell you that the current leaders in New York City of the labor movement, they're not for this. And they, by and large, have come to appreciate the importance of exclusivity to them, which is a good segue to what what are unions, what is the movement doing in anticipation of the loss?
Before you get there,
Sure.
can I just raise what
Mhm.
isn't the struggle here a manifestation of the more very fundamental issue that took place when public sector bargaining was being considered? There was tremendous opposition to it on the basis that you can't have the elected officials, there's an inherent conflict between the elected officials bargaining with the people who are raising money and supporting them in the elections, and there's a feeling that because of that conflict, a lot has happened in the public sector that, in terms of largesse to the unions, that have put cities and municipalities in difficult financial positions. So is this an attempt in some way to get back and weaken, if you can't get rid of the public sector bargaining, let's weaken the unions? Just interested to hear what Sam or Alan you have to say about that view.
Well, one, at least in our local experience, Mayors Giuliani and Bloomberg didn't seem too troubled by that in their negotiations. But I understand and accept your point. One of the things that's happened is that certain terms and certain aspects of bargaining have actually been taken out of what is bargainable because of what Fred. So, for example, in New York, there was thought to be an abuse in pension benefits because basically it was seemed to be too easy a way to provide benefits to the workforce, which actually wouldn't cost the current administration for years to come. So what happened in New York is that it became impermissible to bargain over pension improvements. You can, in reality, sort of talk to whether it's the city or the state or other municipalities, you can talk to them about supporting legislation, but then that goes to the legislative body, but there has been a change in that.
If I can follow up on this point, the problem for me with Janus and Friedrich is that it violates the principle that people have a right to be paid for their services. And if they're not going to be paid for their services, you're either going to use the whip as Soviet Russia tried to do, which was also not an equilibrium position, or you're going to get less work, less quality work, less effort. That's just the nature of we human beings. So that's my problem, and it's going at this issue that Fred raises, which is a real issue, but it's going at it so indirectly that it's going to ultimately kill the baby with the bathwater. The unions have a right to be paid. Now, if you have a problem with the scope of bargaining, that's something that needs to be dealt with separately, and there are issues there. If you have a problem with the quality of public sector management, that's also something, because the system really only works if public sector management is out there vindicating the interest of the larger public. That's also something that should be addressed directly. The problem here is trying to completely defund the organizations so they can't even perform collective bargaining functions that don't involve these political issues. Let's go on to another possible response. You said employers giving better pay to union members, is that?
Well, what has happened is that ways of looking at this, so this is part of the reason why the members only, which I agree with Sam, is not a way to go. It doesn't work. What happened in New York in April and is now being used as a model in other states is to bolster support the public sector unions. There have been amendments to the state labor laws. So there was an amendment to the Taylor law here. I gave out to some of the tables, should anyone want it. It's not the most exciting reading. I have copies of the statute here as to what was passed in order to try and give a better support or better balance to it. And what New York did, and I will say the unions probably benefited from this being an election year for the governor, but what unions were able to accomplish were changes in 3 areas. One as to member mobilization, second solicitation for them, and the revocation of dues authorizations. And just spend a minute on each. What the amendments to the Taylor law did was to say, one, they gave as a matter of statutory right, unions have now the ability to go and meet with new members, new workers when they're hired. And there, in New York City, there was some procedure, this was in place for some unions, like the uniformed forces where they hire as classes, it's easy, but not for other unions where people come and go all the time. They also made changes as a contractual matter that right now what the state law did until April was to basically say you could leave union membership at any time. And then under the new system, what might happen is that you would have people who would want to benefit from the union and what the union does. And if not, they would drop out, then they would come back. Or more fundamentally, if you could drop out any time, unions would have a hard time budgeting. They wouldn't know what resources they had. So that aspect was changed under the General Municipal Law 93B, which is, and we do expect this to be challenged, is that you can leave union membership at any time, but if your union authorization card says you are nonetheless obliged to pay your dues for the full year as a matter of contract, there is a strong belief that that will be upheld. It was upheld by a federal court in state of Washington last year, I believe, where the judge said, look, this is a matter of contract. No one forced you to do it. And so that at least, can give you the bargaining for the, your resources for the year. But the most important aspect what happened, and it comes to the question from over here, is this notion of the duty of fair representation, which goes hand in hand with exclusivity. As we said before, you get to be the exclusive bargaining representative. But what comes with that until now was that you have to treat everyone fairly, equally, justly, regardless of whether they were a member or not a member. And that was strongly held in PERB, the Public Employment Relations Board, the New York City Board of Collective Bargaining, and in analogous situations in states all over the country. Think about now what we were talking about with the free rider syndrome, is that if the union has to provide everything to you because they're the exclusive representative, regardless of whether you pay or not, there seems to be an imbalance and unfairness to that. What New York did is, in the materials here, what New York did was change the duty of fair representation. What they're saying now is that it essentially limits what you're obliged to do. And this is the floor. Unions can decide to do more. But what you were obliged to do is now limited really to the obligations that come out of the collective bargaining agreement, things that we consider the core rights that are part of that contract. So that you can provide member-only benefits on aspects that are legal, economic, or job-related, so long as they are beyond or outside the agreement. That is viewed as something, and look, there were some people within the union movement that didn't want to go that way. They said what unions should be interested, unions should be doing, is proving to the members their worth, that there is value and it's worth the payment. There was a lot of discussion, and our views, we collectively working with others prevailed, that's very nice. Unions should be doing more. Frankly, a lot of unions had grown complacent because they were getting the agency fee even if they weren't members. And over the last year, where the specter of Janus has come back, a lot of unions have been doing more to touch their members, to interact with them. However, the feeling was, given human nature, that wasn't going to suffice. And what unions wanted to do is to be able to say, look, if you're not a member, here are the list of things you're not going to get.
What are some of these things?
So
Extra contractual benefits.
So extra range from insurance programs that the unions may do, pension counseling, but most fundamentally, representing members in disciplinary proceedings. Because unless that is something that is enshrined in your collective bargaining agreement, and our advice to clients is that they should be looking at their contracts to see if there are things in the contract that don't have to be there, that things that are the Weingarten rights from the private sector, and here, these are things that a union no longer has to provide. And again, it's a question of choice. The one area that we are advising people not to try and move out of is the grievances arbitrations over the interpretation of the collective bargaining agreement. There is an argument that you shouldn't be doing that either. However, we think that it is dangerous for union leadership to cede proceedings that have to do with the interpretation of their collective bargaining agreement, because it's not that it's so necessarily precedential, like the Second Circuit ruling on something for the district courts here, but there is a strong feeling that we don't want others administering.
On these disciplinary, you're saying there are disciplinary procedures that are not required by the contract.
Right, so for,
That an employee can choose between
yes,
and
so for example.
statutory provisions.
Yes, in the teacher movement, that's what I was going to do. It's in the newspapers a lot. It was in the newspapers, I think, last week, that people are complaining that it takes too long or it's too expensive, too cumbersome to remove teachers that are tenured. It's section 3020A of the state education law. Our argument would be that unless this was something that the United Federation of Teachers or other teacher unions throughout the state had enshrined in their contracts, that this is not something that they have to provide to the members. And what is conditioned on is the fact that you then can't control it. It can't be that you can only use the union and the union won't do it for you. That won't hold, because that will be a violation of the exclusivity and other principles. But they're saying, you're not a member, we don't have to provide this experienced team of lawyers to represent you in disciplinary proceedings, you're on your own.
Gotcha. Okay, any other responses that we're considering? What about this proposal that the state pay for reimbursable activities of the union representative, the government pay for
So
the
one,
the reimbursable activities of the union representative?
One of the issues that are out there, because again, and the reason that government might do this is because government is concerned about the collapse of the collective bargaining system. One of the things that are being discussed is is there a way for the government to cover the expenses of certain things that the union was paying for. So what Sam is referring to is, if you look at the notion of what were chargeable activities under the law that exists right now, things like contract administration, representing people in grievances, can it be that the employer will, as a function of bargaining, it would be part of the package? And it's not would be, because I can anticipate Fred's question, it wouldn't be part of a gift to the unions, it would be part of a package.
Bargain for.
Can that work? There are two issues with this that need to be played out. One is, there is a concern that if your members know that the employer, the person they're bargaining against, or the person that's seeking to discipline them or to take away certain rights they have, that the employer is helping to fund the union, is there going to be a concern of an appearance issue or an actual threat to the independence of the union? So that is a concern that's out there, which I think, if that were the only concern, some unions would be able to get over as a way to stabilize their resources. There is a second legal issue that's there, which Sam has written about a bit, which is whether the Taylor law in New York is not the same as the private sector proceedings on the issue of forbidding employer contributions to an employee organization. There are PERB decisions which import some of the Section 8A2 learning into it. There is a concern, but even in the public sector, about is the employer exerting domination or control or too much influence on it? That could be a fact-specific item, but that is something that's being looked at now as a way to help stabilize the resources, is the government stepping in. There's also the possibility out there that there may be certain things that a union does outside of this, that there could be certain, for example, professional development activities that they provide to their members that cost them money. And is this something that maybe the government can subsidize or fund? And again, some of these legal issues have to be worked through.
You also have to have a pretty tight definition of reimbursable activities. I think having the government fund the political activities, or even the political activities in support of clear collective bargaining goals, at the very least is an appearance problem, but even beyond that, I think so. But I think this is a way to solve the problem. It may change the unions in a very bad way. It's something to think about. Anything else that you're considering?
Yes, there's one that Sam had an article published.
Section 19 of the Taft-Hartley Act, yes.
Yes, had an article published in Bloomberg on March 2nd suggesting, where I guess here you are predicting a little bit because the title is How Unions Can Survive a Supreme Court Defeat.
Well, in fairness, my editor dominates me on the titles.
And so the suggestion there is, and again, and I think what Sam was raising here goes to the psychology of the worker, is that in order to avoid the free rider temptation is to say, you don't have to join the union, but then you have to make a comparable contribution to a charity of your choice or a 501c3. And you can,
So the basic idea is there are like two problems. There's a free rider problem, and then there's a conscientious objection problem. Now, I don't know how many conscientious objectors are out there, but there are people that object to being in an association with a union, having the union speak for them. Now, the problem with the Janus situation and how it's going to play out is that we, in the guise of advancing this conscientious objection problem, you are basically going to undermine the funding of the organization because of the free rider effect, which I think is inescapable. It's an inherent part of the exclusivity situation. So the idea is put the worker to the choice. If you want to be a conscientious objector, absolutely, you have a right. I wouldn't limit it to religious. Section 19 limits it to bona fide religious objections. I'd include political and ideological objections. If you have an objection to belonging to the union and paying for the union, that is to, we recognize it. This is a First Amendment, we're all subject to it. However, you can't engage in, you have to pay for the costs of the representation going on, for the costs of the collective goods that are being provided, your fair share of those costs. You can't sit back. Otherwise, the organization that's providing those collective goods can't function. It's like I happen to have a house in a small town in Massachusetts. I'm not privileged to say, you know, I don't feel like paying for the fire department right now. Because, you know, I have an objection to big government. Fires are fairly infrequent. My house is built of the best possible lumber. I'm nowhere near another house. And you guys you dominate the local board meetings, and I don't want to waste any time. Now, I can say all those things, but I got to pay my taxes. If I didn't pay my taxes, people would underfund the fire department, and guess what? We'd have fires, and they'd spread to other houses, and at some point they'd say, let's go back to taxation. This is how government starts. So the idea is to separate out the conscientious objection problem from the free rider, and basically create a right to not be a member of a union and not pay to the union. The money goes to a 501c3 organization of your choice. I think Section 19 is too restrictive here. Now, what if it's going to be the Right to Work League? So be it. The actual experience we have under 19 is there's a very little take-up rate. You know why there's a very little take-up rate? Because workers are rational. If you tell them, you know, you can object to the union, but you still have to pay, guess what? They're still going to pay. It's not worth it. It's not worth it then. The conscientious objection is really not salient. It's the right to ride for free. And I think the union movement can position itself in a very different place. There are going to be a whole spate of collection actions after Janus. Again, I'm not making short-term predictions. The premise here, and this is really Alan's prediction that I'm piggybacking on, that Janus will lead to the overruling of Abood. There'll be a whole host of collective actions across the country. If you tell workers, guess what? You get everything you would get if you were a dues payer or a fair share payer, but you don't have to pay, and guess what? All you have to do is fill out this postcard, and you'll get $10,000 in the mail. People will fill out that postcard. You know, I'm not a genius. I don't have a PhD in psychology. That is going to be the response. If, on the other hand, they're told, if you fill out this postcard and say you're a conscientious objector, and you still have to pay whatever it is, they're not going to fill it out. It's not worth the candle for them. You get the stuff in the mail all the time. They say, look, you can be a member of the class action that we have negotiated for you. It gives you a right to a coupon, to a 20% discount on the next Ford automobile you buy, even though the subject of this lawsuit was a products liability claim against Ford. We don't fill out those forms. It's not worth it to us. There's not enough of a gain to us. So anyway, this is human nature at work here. Low turnout rate. So what the union movement should do, they're worried about doing it. I'm not sure I know why. They should adopt this approach. Is it foolproof? Nothing in life is foolproof, but it puts them in a very different position in the next spate of litigation. Because right now they're naked, unless they just get rid of some of their exclusive activities and the various approaches or have the government pay for them. So anyway, I think there's a lot to be said for Section 19 modified so as not to limit it to religious objections only, but to include religious objections, and modified to allow any 501c3 organization of the employee's choice. And the idea is revealed preferences, and that is pull separate the conscientious objection claim from the free rider impulse.
Right. And the the collection of actions that Sam is referring to, and here, if my judge were still alive that I clerked for, I would apologize, because I clerked in 1981. We had a libel case, was for a wonderful, clerk for a wonderful judge on the New Jersey Supreme Court.
Who was it?
Schreiber, Sidney Schreiber.
Sidney Schreiber.
And the New Jersey Supreme Court, very active, proactive. We had a libel case. My judge graduated from Yale Law School in the 1930s.
Again, you're pitching another law school. I don't understand this now.
New York Times versus Sullivan was something he knew about but hadn't really understand or digested. And I'm saying, judge, changed, okay? Sam started to talk to me about Section 19 over a year ago, and also...
I'm the only one in this room that knows about Section 19, because because I have this book, I have to read it all the time, make sure there aren't any typos in the law.
And he also predicted over a year ago that we're going to be flooded with suits for retroactive refunds to members. And I'm thinking that I know the Chevron case from the Supreme Court about this. This isn't really going to be a problem. What I have to apologize for is Sam said to me, you know what, Chevron's not good law anymore. So then we took a look, and a lot of people have looked at this, that there is going to be retroactive, assuming the case goes the way we've been discussing.
To some extent.
There is going to be, to some extent, a retroactive application. However, what the Second Circuit and other circuits seem to be very clear on is that you can have a good faith defense to it, that still is recognized. And I do think that should carry the day in terms of the reliance since 1977 on this, the fact that you shouldn't be able to presume that there's going to be a change in the Supreme Court on constitutional law, the fact that we have been recommending to unions that they have it set up. We've taken care of this with the City of New York, that if in fact there's an adverse decision, that the deducting of agency fees stops immediately or as quickly as practicable, so that if in fact the payroll isn't already within the computer system to go out, that very next payroll no longer takes the agency fees out of it for those jurisdictions where they can't be as quickly oriented, to see if those monies can be put in escrow, so we can show the court system that we weren't trying to take advantage.
Anything else?
The question here?
By the way, this is a procedural error, please forgive me. Go to the microphone when we take questions. Walk to the microphone and identify yourself, because we're taping this. We want these words memorialized for all time. There's a microphone in the back of the room. Do you have any other? Larry, you're going to have to play by this procedure. I manage the entire room this way.
Well,
Where are you, Tori?
just
All right, is there a microphone here?
She's passing it out.
She's passing it out. Allison?
Okay. I'm familiar with United Federation of Teachers, okay? And the reason is my organization was a part of it a number of years ago. I represent doctors. And I understand they're an incredibly efficient operation, extraordinarily well-run politically. They have a system that's better than the Democratic Party.
like phone banks and things like
I'm
that.
just, it's a fact. So, since you're familiar with it as well, if you have a $100 coming in this year as a result of you have to pay, what's the projection over 2 years as to what this rule will impact on your budget? How much will you lose financially?
Look, we don't know here because states are different. I can tell you in the Michigan Teachers Union lost 25% over 2 years. We believe it will be less because of the proactive work that is being done in New York over the last several months and right now. And frankly, without getting too political in this room, we feel that what's happening nationally should help the New York unions retain more of their members than they might otherwise.
Okay, you had a transit strike here a number of years ago with Quill. When Quill, I'm older than most people. So,
There was a second one
You're
with
talking
Tucson.
1966,
okay, and
Larry?
because of the Taylor law, well, people didn't have to pay dues, right? So what was the percent there with the?
There was a significant, what happens if you violate, New York has no strikes for public sector workers, which actually is not necessarily the case throughout the country. New York is more onerous on that. In some jurisdictions, it's only police and fire can strike. But in New York, the prohibition is everyone. If you strike in violation of the Taylor law, you lose your right to dues checkoff. You don't lose your right to dues, but you stand to lose your right that it can be automatically done by the employer. And when that happened to TWU, there was a massive loss of revenue.
So
Larry,
what's the answer? How much do you project the teachers' union's budget from collections will go down?
I don't know.
He attempted an answer, Larry.
Excuse me?
He attempted an answer.
He can't
before.
give you an answer?
Right, he doesn't know at this point.
Okay.
It varies by state, he said. Thank you. Are you ready for questions generally?
Yes, just the last thing is just reference that, as mentioned earlier, because Sam raised the issue of exclusivity. Another reason why this should be a concern, both in the public sector and private sector. And I think the remarks from the Taylor Law program jointly sponsored by Cornell ILR that Professor Estlin made, that I think they are going to be produced. So that part of the argument there was that this attack on exclusivity, which we believe should be defended, may also come to the private sector as well. So that there is
It may have spillover effects on the private sector.
I have a
Are there
quick
other questions
question.
in the rear?
Yeah, my name is John Janopoulos. I'm a judge at the NLRB. Mr. Klinger, you touched on this briefly, but I'm curious, and I haven't studied Abood, the background of Abood, or the facts or background of Janus, but how do we get from what's basically a unanimous decision in Abood to now what looks like it might be a 5-4 decision? Were the facts that different in Abood? Is it just the ideological makeup of the court? If you could just, I'm just curious.
Okay, one is that the fairest, or the nicest I can be, is there has proved to be certain, sometimes hard lines to draw between chargeable and non-chargeable. To me, that is eminently remedied, and I think that we've seen a change in the composition of the court in the 40 years.
Other questions?
Yeah, I had a quick question
Could you
about
identify
this.
yourself, please?
Erin Schaefer with Region 29, the Brooklyn
Thank you.
NLRB. You talked about this spilling over into public sector. As part of the negotiations for NAFTA, or the renegotiations, Justin Trudeau has asked the United States to eliminate right-to-work laws because it's causing loss of manufacturing jobs from Canadian workers to cheaper American labor. And Kristen Gillibrand and Sherrod Brown have introduced legislation that would eliminate right-to-work laws nationwide. Do you think that the Janus decision would render that essentially unconstitutional if Janus rests on a First Amendment argument?
We don't know what the Supreme Court is going to hold in Janus, how broad it's going to be. But there'll be pressure on that, I think. I don't think you can, you'd have to have legislation. I don't think you can, by NAFTA, overturn 14B of the Taft-Hartley Act as a statutory matter. You'd have to have legislation, which I think is improbable at this point. Depending on the breadth of the decisions and subsequent Janus decisions, there might be, it's a hypothetical statute, there might be problems. Any other questions or comments?
Someone's going through the mic.
Good.
Yeah, Maury Kaufman. I'm actually here out of the state of Michigan, and so I'm the president of the labor union at Michigan State University. I've been in that role since 2008, so I've lived through that change of being an agency fee and then now being a, as we like to call in the union world, a freedom to freeload, or commonly referred to as right to work. And so I guess a couple things. One is to the previous question, in the Michigan example, we are affiliated with the MEA, the Michigan Education Association. Part of the significant difference, I think, that you would see in Michigan versus what you might see here in New York and some of the other more traditionally blue states is that there are multiple other attacks on the labor unions themselves. So membership has reduced, but part of that is also because we've lost other elements like payroll deduction of dues. So we have a different challenge in how we actually can collect those dues from our members. And then on top of that, the bargaining laws have constrained or constrict a lot of elements that we actually can go to the bargaining table over. So whether it's you're talking about calendar, or whether you're talking about teacher evaluation, whether you're talking about different compensation levels, all of those things continue to get constrained or constricted. I guess my statement, and I certainly would welcome any feedback, I too share in your perspective that I think the Janus decision will be unfavorable to public sector labor unions. To me, though, what has really changed in my life in the last decade that I have served as president of the local labor union is that my time has to be spent very differently in what the union is doing. So a lot of my time used to be involved in contract enforcement and engaging the employer, building those relationships, trying to represent those individual members and collectively the bargaining unit. Now, it is me spending a lot of time out in the membership, face-to-face, one-to-one, with as many people as I can, trying to convince them or persuade them as to why they need to join and pay for the union. And as a side note, the opt-out window used to be in August, and our state actually ruled, our Michigan Employment Relations Commission, MERC, ruled that the idea of having an opt-out window was viewed as coercion to the union, so now you can opt in or opt out at any point throughout the year. So, I think there are many different challenges, and we've fared much better than like a Wisconsin, which
Right.
has done much worse. So I just share that as a matter of perspective, not as like a legal technical side. I am an attorney, but at the same time, the practical functional side of trying to live in this environment.
Thank you.
Thank you. And talk about the opt-out window, so this again is left to the discretion. The law changed in New York such that you can now put in that you can only, there's a fixed time to opt out. How you choose to do that is left to the unions. What we're saying to people is don't try and be too cute to say you can only opt out on the anniversary of your signing the membership card, where few people remember when they signed it to begin with. What we're saying is that if you want this to withstand attack, pick a period of time. Like in New York, there's usually 3 to 4 weeks where you can change your healthcare enrollment. Do something like that so that it's a period that people know. And again, unions will choose what to do, and we do anticipate there's going to be an attack on that. But thank
Other
you.
questions or comments? Fred, do you have any?
Well, I don't know what the answer is, but I think this really all goes back to the fight that existed in the late 50s and early 60s over whether it is really possible for elected government officials to deal objectively because of their inherent conflict of interest, as you just said, Alan, when Larry was talking about how well organized the UFT is. The UFT does have phone banks. They're on the phones. They're pitching for their candidate. And can that candidate, if elected, are they going to turn on that person? Can they really be objective? And I think, to answer the administrative law judge from the National Labor Relations Board, I think what we may be seeing is that the concerns that existed at the outset have now manifest themselves. There's a general feeling that we see cities going bankrupt because of the pension plans, because it is true. One administration can make an agreement, and some other administration is going to pay for it. I don't know what the answer is, how to deal with that, but I think that's the root problem, and these are just all different ways, and Sam, you're probably right. They're indirect, but they're an attempt to deal with this problem. I don't know what the correct way to deal with it is, but I think that's what we're living with.
Other comments? Alan, do you want to comment? But to some extent, the public sector unions are victims of their own success, is what you're saying.
Yes.
And also the weakness of public sector management. You know, when I was I did my master's on Mike Quillen at Transport Workers Union, because when I was in high school, I had to walk from the Bronx through Harlem to Brooklyn, because I went to high school in Brooklyn. There was a transit strike in 1966. The public sector management's idea of taking a transit strike is let the public suffer until they say, ouch, give the TW what it wants. This is a very strange concept of collective bargaining. You try to maintain operations ordinarily, so that's a problem. Any event, you need a strong public sector management in order for this system to work, because public sector employees have a right to an organized voice, but you need a strong management on the other side. And part of the problem is, maybe the union role, but maybe just the path of least resistance. I don't know.
Well, but how strong can you be, Sam, if you are depending on the phone banks and the election activity?
There have been, we know there have been different mayoral philosophies here. Giuliani, Bloomberg, different approaches to collect. I think there was no contract, no contract was signed during the Bloomberg administration. There are different approaches. There are two different parties that take different approaches here. I don't think it's that stark a conflict of interest problem. I think it is. I think it's something we ought to be demanding of our public representatives, that they do a better job in this area.
Just one footnote, we'll be leaving for later today, is the Municipal Labor Committee is negotiating with the City of New York, helping the City of New York deal with some of the rising costs of healthcare, with medical care, hospitalization. We are finishing a 4-year agreement where $3.4 billion of savings were realized to the City of New York, with labor and management working together. So I do think, and we're now negotiating the successor agreement to that. So I do think there are also positive things that come out of this
And more needs to be
relationship.
done on the pension side. So there may be areas of joint interest that require public sector managers to take a more stronger position. So we should all be for good management of public services. Other questions or comments? I don't, yes, Larry.
Yeah, I think,
Can you get a microphone to Larry, please?
yeah. I happen to live with this problem, so I'm a little into it. I think you make it complicated, Professor S. Stryker.
Thank
I have
you.
a transit card in my pocket.
That's my job. Yes, go
Yeah.
ahead.
Let me see if I have it here. Here it is, the transit card.
Yes.
If you give me a chance not to use this transit card and just walk through the door to get on that subway, which I use every day, right? I'm going to open that door. I may not at the beginning because I feel a little guilty. I like the trains. But if I see everyone else walking through that door, which is right next to where you put your card in, and I can get in for nothing, I'm going to go ahead and eventually walk through that door and not use my transit card. So when you give people a chance to get something for nothing, which is really what this case is about, or they have to pay for it, at the beginning, a lot of people will pay for it. Then when the guy sitting next to them or the girl sitting next to them says, "Hey, jerk, I'm getting the same thing you're getting,
Right.
and I'm not paying."
I agree with you, Larry. That's why I wrote an amicus brief on behalf
Excuse me?
I wrote an amicus brief on behalf of most of the leading labor law professors in support of the union position here. People have a right to be paid for their services. If they're not paid for their services, those services will go down in quality and in quantity. I agree
They're
with
going
you.
to get the same services, Professor Stryker.
I don't think that's true.
I don't think the teachers' union, for example, is going to cut its services.
Well,
They're going to give them the same thing, and the person over
up to a
there,
certain point, up to a certain point. But at UFT...
it's a good union, Sam, and they're going to give
All
them
right,
the
well,
service.
talking about other unions across the country. Anyway, anything else, folks? You have a comment?
Sure, I'm Pam Silverblatt. I'm responsible for labor relations at the City University of New York.
And former first deputy for City of New York.
Don't say that. And have negotiated health on the other side of the table. So just a couple of points to underscore that were made, but that I think really are critically important. I think that New York is very different than the rest of the country, and I think it's going to be extremely different in the way it plays out, even subsequent to a Janus decision that may go against the unions. I know we were all shocked some years ago about what went on in Michigan and Wisconsin, but the reality is that the politics in Michigan and Wisconsin, including a governor in Wisconsin who wanted to gut collective bargaining, are so different than New York at this moment in time.
Right.
And the state legislation to which Alan referred earlier was done in advance of Janus to ameliorate, literally to ameliorate the effects of it. And the governor, in signing the legislation, I think at the UFT headquarters, maybe.
Yes.
Yeah, I thought so. Picture looked familiar. Was so supportive of New York needing to facilitate in continuing union access, and in effect, in expanding union access, and expanding the public sector employers' obligations to provide information that I have to believe, and I say this to my colleagues from other places in the country, that New York is atypical and is going to be atypical. So, you know, that's one part. The other part, and, you know, I hear what this gentleman is saying, but having negotiated on behalf of the city with many of the unions, it's fair to say that there are many unions that are not as well-resourced or well-organized as the UFT. The UFT is huge. You know, in the years that I did this stuff, the cost of a 1% increase for city employees was X dollars. UFT was 1/3 of X.
Right.
So
Right.
they have resources that the other unions don't have, and that's even before unions sustain cuts. So I want to make that observation. There are many, many, many smaller,
Right.
less well-resourced groups. I do think that the city's amicus brief in support, which went through, I'm assuming Alan wrote it, it went through the history in the city, including the series of transit strikes, the sanitation strike that Mayor Lindsay suffered, and the reasons why in the public sector in New York City and New York State, there is a strong belief that public sector unions are the right thing to do.
Right.
So it's going to be interesting. I guess the one question that I have hanging out there, and you know, sort of rhetorical, not looking for an answer, is the extent to which the unions, public sector unions, take this as a clarion call to have to look inwardly as to whether or not they need to become more efficient, need to spend their resources in different ways. I think the word was used this morning in terms of complacent. I think that's part of why in the Midwest and other places there has been the ability to get such a groundswell against public sector unions and public sector employees. And so I wonder the extent to which the unions may use this as an opportunity to streamline some of their spending. And you don't have to respond.
No, actually.
Thank you very much.
I mean, the clarion call is what has been done. A lot of the larger unions spent a good part of this year first evaluating why they had agency fee payers to begin with, and have worked to convert the agency fee payers to actually full members in the hope that that will keep them in a post-Janus environment. And yes, unions are looking and preparing for what is to come.
All right, little pitch. I did a piece on federal sector unions and why do people pay dues when they don't have to in the federal sector. The piece is outside Employee Rights Journal. Please join me in thanking Alan and Fred and for a terrific discussion. You have a 10-minute break. We'll see you at 10:20.